Ultimately, no law can completely fill in the gap left by morality. So that's where we are. If Mr. Sibal said the speaker in such a delicate constitutional issue, your lordships are embarking on a journey which has no destination.
By the petitioners. Just so that the facts are before you.
I accept my friends.
Any disqualification
notice was never given of that.
Yes,
1 minute. Any disqualification notice you had given?
Yes.
No.
No notice was given. Please take a
Petition was filed.
Now you can't say this is the law, so on this I'll get a stay, but I'll get up and argue that this law is wrong.
In this petition, in the counter affidavit, did you say that Nabam Rabia is wrong?
No, man. Yesterday, impassioned plea by Mr. Sibal saying how the defection law has failed to curtail defection. And my lord, yes, of course, ultimately no law can completely fill in the gap left by morality. So that's where we are. If Mr. Sibal said the speakers have failed to rise to the occasion, my lord, I don't think there can be any cavil about that, the kind of cases which have come. But also, my lord, equally, this we should always remember this was an anti-defection law, not an anti-dissent law. The challenge and the criticism include right from the late Mr. Palkewala, who was one of the great votary of political morality. Always the criticism of such law also used to be that this becomes an anti-dissent law. And that is what this is being converted to today. If I give your lordships 5 or 6 dates, your lordship will see that none of these petitions survive. Unless your lordships, and that is not really even for a bench of 5, unless your lordships come to the startling conclusion that under 142, applications pending before a speaker can be transferred to this court and tried. And that's one of the prayers in one of the writ petitions. Or an even more startling conclusion saying the moment there is a disqualification petition filed, the candidate stands disqualified until he is requalified by rejection of the dissent petition, by the defection petition. But those are not matters, my lord, which 5 of your lordships will refer to 7. What your lordship is today concerned is with the Nabam Rabia problem. I will not take any time reading that judgment beyond saying that there was a serious problem in that case. There is a strong argument that you should not hold speakers to be in suspended animation merely because a removal is pending. But Justice Misra particularly, Malad, brings out the counterpoint. Suffice it to...
Justice Misra brings out their voice.
The counterpoint.
The counterpoint.
Yes. And I'm only saying this for the reason these are delicate constitutional issues which should be resolved in a fit case where the question arises. Does the question arise in this case? And the answer is a resounding no. And let me tell my lord why. It is, my lord, in our counter affidavit, if your lordship turns to page 494 of volume 1, convenience compilation. What exactly happened and what has happened and where are we today? The only petition in which Nabam Rabia today is a live issue is a petition settled by Mr. Kamath, who perhaps realizing the folly of his ways has argued that Nabam Rabia should be reversed. It's a petition by a group of people against whom the Shinde faction has filed defection petitions. They have come to your lordship saying because of Nabam Rabia, because we have applied for removal of the current speaker, do not allow him to continue. Now, if they say the judgment is wrong, all they need to do is withdraw their petition. Look at that, my lord, for a minute. Because I think that's what is important to know. In such a delicate constitutional issue, your lordships are embarking on a journey which has no destination.
The actual scenario was this. By our order of 27th of June, we had extended time until the 12th of July.
11th of July. Sorry. 11
the
July.
disqualification notice.
12th July.
Yes.
But in the meantime, as a result of the direction of the governor, the floor test was to be held on
Yes,
30th. In other words, the
30th.
floor test would take place without the speaker applying his mind to the disqualification.
Correct. Correct. They came to your lordships and said, stay this meeting.
Right.
Your lordship said no. Now, the legality of that meeting is no longer an issue because Mr. Thackeray resigns.
So these, according to you, wouldn't have made a difference even if their votes were to be excluded.
Even if there was a meeting in which they had voted.
Just factually, 27th June, 22 more were sought to be disqualified. Just
27th.
7th of June, 22 more were sought to be disqualified by the petitioners. Just so that the facts are before you.
Yeah,
don't want to
I
interrupt.
accept my friend's
Any
view.
disqualification
Notice
notice
was
you had-
given of that.
Yes, yes.
1 minute. Any disqualification notice you had given?
Yes.
No.
No notice was given. Please take a.
Petition was filed. Petition was filed. That's all right. The petition was filed for 22.
This was only the initial notice.
My lord, may I?
I'm
So
just
let's,
stating the facts.
the facts are clear. Our writ petition related to 16. For the balance 22 petitions may have been lodged, but the speaker took no action. On 27 June. This is when Mr. Thackeray is still chief minister. Would these people have changed their mind in view of the pendency of the petition and supported the chief minister? Would they not have supported the chief minister? All those questions don't arise because there was no trust vote.
For their petitions to be really live petitions, that they should have faced the trust vote.
Yes, ma'am. Then some questions may have arisen
Voted
about
out of
what
office
happened.
on the trust vote.
Yes.
And then you would know who are the actual people who voted
Exactly.
in favor of the trust vote and who was sought to be disqualified.
That's right. None of that ever happened. Now, my lord, 30th June, let me, and my lord, one thing is clear, by now Nabam Rabia has all become academic.
What happens is really the two orders, the two judicial orders really seal the fate of the
Correct, my lord.
first order of the 27th,
Yes, my lord.
which says that, we give you time, extend time until the 12th
Yes.
to submit your reply on the ground that the speaker had given only 2 days time. Therefore, the first order says time until the 12th. Then when they came back to the court, challenging the convening of the trust vote on the 30th, our court said no stay. So really speaking, everything, it was these two orders ultimately
And,
which
but
affected
my lord, there's a
first
third.
order had the consequence of
Yeah.
not allowing the speaker to go ahead with the disqualification petitions
Of 16 people.
before the 12th
Of only 16 people.
of 16 people. And the second order had the consequence of ensuring that the trust vote takes place on the 30th.
Correct. Except the
And they
trust
knew,
vote.
I mean, the Uddhav Thackeray faction knew that without a decision on the disqualification petition, the trust vote was sealed then.
My lord, there also I'm saying the gap was, no, my lord, the gap was 16. No, that's not correct. That is not correct because, my lord, the disqualification petitions which were deferred by your lordship as 16, they had 58 majority.
I beg your pardon, come again?
The 16 petitions were adjourned.
Right.
The gap was 58 between the BJP and the Agadi.
Yes.
So if you take the 16 out,
That's not the point. Eknath Shinde became the chief minister.
first Mr. Thackeray resigns, then Eknath Shinde becomes chief minister. It's not in the reverse sequence.
So what?
Now, there is no legal, if Mr. Thackeray had contested the election, the effect of which had been in any manner impacted by the non-decision of the defection petitions, some question of law may have arisen.
Uddhav Thackeray, he resigned because of the communication of the governor to hold the trust vote.
Correct. My lord, if he had
He
gone,
knew that, well, if I have to face the assembly the next day,
Yes.
Without the disqualification petition being heard, he doesn't have the numbers.
No, my lord, that again is wrong. 16 disqualifications alone were stayed.
Yeah,
11
that's what
July.
you made. 16 plus 22 also you said if you exclude.
38, there's still 58. Secondly, my lord, as a court, political events, your lordship is right. But as a court, if he did not face the trust
I mean,
vote,
what you're saying is that there was never any trust vote, so why challenge the communication?
I mean, it's academic because there was let's the communication goes, what happens? The meeting doesn't go.
It's academic in the legal sense, you're right.
In the legal
But
sense. Correct.
it's all part of one
And
intrinsic.
that's why, my lord, that's why in my respectful submission, it is hazardous for your lordship to be drawn into.
Right. Anything else, Mr. Salve? Should
Yes.
we
Just want to finish the record.
20 minutes by about 20 minutes?
Yes. My lord, the two more writ petitions remain. I just want to.
Yes, which are they?
My lord, that is, I'll just give your lordships the bookmarks. Item 10, that is challenge to Mr. Gogavle.
2479.
But what is important, my lord, and I finish with this, is item 11 by the petitioners.
Item 11.
Yes.
That is Sunil Prabhu.
Relying on Nabia and on which the speaker has held his hand because there was an understanding that nothing will be done. And now they are saying this is wrongly decided. Page 412, my lord, your lordship has page 412.
Page?
412.
Yes, and the prayer is at 461.
Yes. No, before that, please just see 414.
414.
Yes. There is a paragraph saying secondly.
It's true because we are saying that the law has no law.
Now the petitioners are saying this judgment is wrong. But there has to be some rule of holding people to what they have come to court.
Which is
Never apply to.
414 you said.
Second.
Ye kahan hai?
Page
411 otherwise.
411.
411 on the right side, Mara. I believe the PDF page is 411.
That's right.
This is their petition, right?
Yes. Which relies on Nabia Rabia. Now you can't say this is the law, so on this I'll get a stay, but I'll get up and argue that this law is wrong.
In this petition, in the counter affidavit, did you say that Nabam Rabia is wrong?
No, Mara. we were careful. except the roles are reversed. I will end by.
The survey, the bottom line is
Yeah.
Nabam Rabia becomes right or wrong based on, which side you are in which political situation.
But I will only end by.
Somebody or the other is supporting it. The same people are supporting Nabam Rabia. The same people oppose it, depending upon which way.
I've said what I had to say about this, Malad. This is not a fit case to decide these issues. I will only close, Malad, with a story which Mr. Parasaran once told us. He told the Constitution bench of your Lordship's Court, saying in Satyug, a man was a tenant of a farm. He found a pot of gold. He went to the owner and said, this belongs to you because I only have the farm for cultivating grain. The owner said, no, God willed you to get it. That is why you discovered it. So they had a dispute. They went to the king, by which time it was Kalyug. So contrary to their pleadings, as he explained, the tenant said, this is mine because I found it. And the owner said, no, this is in my land, therefore it is mine. So that is what is going on here.
And ultimately, king said it.
Seizes power, gets the pot of gold.
What the king said is what I want to persuade your lordships to hold. Don't waste my
For
time.
any treasure, we have an act, right, in India. We have an act of 1972. The Treasures Act. When a treasure is found, it belongs to the treasury.
Yeah, it was.
The Constitution.
I was only going to close by saying, your lordship should do what the king did. Tell both of them, don't waste our time. That, my lord, is my submission.
All right. Thank you, Mr. Salve.
Lordship, please.